Hello, my name is Chad Rink, and I'm an attorney at Birch, Stewart, Kolasch, and Birch. Today I'll be speaking about Ethicon Endo-Surgery, Inc. v. Covidien LP, a Federal Circuit case decided on January 13, 2016. Ethicon owns U.S. Patent Number 8317070, directed to surgical stapling devices that produce formed staples having different lengths. The asserted point of novelty was the combination of 1. The use of staples of different heights before and after stapling, and 2. The use of staples with non-parallel legs. It was undisputed that both of these improvements separately were well known in the prior art. The asserted inventive aspect was the combination of these two features. In 2010, Covidien began selling surgical staplers that allegedly embody the claimed invention of the 070 patent. Covidien petitioned the USPTO for inter partes review of all claims of the 070 patent on the ground that the claims would have been obvious over the prior art. The Patent Trial and Appeal Board, or PTAB, granted the petition. The same panel of the PTAB found all claims of the 070 patent to be obvious. Ethicon admitted that all of the recited elements of the patent claims were found in the prior art. The board concluded that one of ordinary skill in the art would have been motivated to combine the prior art staplers, disclosing staples of varying heights with staples of non-parallel legs, to securely hold the staples in the cartridge because the benefits of both were well known at the time of the invention. Ethicon appealed, arguing that the final decision of the PTAB should be set aside because it was made by the same panel that made the decision to institute the IPR. The AIA gives the director the authority to determine whether an IPR should be initiated, and the director has delegated this authority to the board. The USPTO has determined that the decision to institute and the final decision should be made by the same board panel in the interest of efficiency. Ethicon argued that this combination of functions is improper because the statute requires the decision to institute the IPR not be made by the same panel of the PTAB that makes the ultimate decision in the IPR. Ethicon argued that having the same panel make the decision to institute the IPR and then later decide the merits of the IPR raises serious due process concerns. The panel of the board is first exposed to a limited record consisting of the petition and the patent holder's preliminary response, so the panel may prejudge the case before seeing a full record. Thus, Ethicon argued that the panel is not an impartial decision maker. As such, the AIA should be construed to preclude the director from delegating the decision to institute to the same panel of the board that makes the final decision. The Federal Circuit disagreed with Ethicon. After reviewing several Supreme Court cases, the Federal Circuit concluded that the Supreme Court has never held a system of combined functions to be a violation of due process. Ethicon argued that the Congress specifically gave the director the power to institute IPR. Congress did not explicitly give the director authority to delegate the institution decision to the board. Congress gave the board the power to make the final determination. As such, Ethicon argued that Congress intended to keep the functions of institution and final decision separate. The Federal Circuit stated that the statute or legislative history does not indicate a concern with separating the functions of initiation and final decision. Agency heads have implied authority to delegate to officials within the agency even without explicit statutory authority. There is nothing in the Constitution or the statute that precludes the same board panel from making the decision to institute the IPR and then rendering the final decision. Thanks for joining me, and I hope you learned something today. Stay tuned to bskb.com for more upcoming videos of interesting cases and other commentary on intellectual property.